This is the Historic District Commission, Town of Fairfield. Today is April 9th, 2026. The notice of this hearing was published on the website of the Historic District. Let's go ahead and take attendance. Darren Raymond Locke. Present. George Clark.
Present.
Art Gavanis.
Here.
Maura Garrick. Here. Jim Accomando.
Here.
Jim Bohan.
Here.
I'm Rosina Negron. Absent right now is Greg Valente. And the meeting today is to for a presentation from Preservation Connecticut and State Historic Preservation Office. And I'll have you guys introduce yourselves, please, and teach us as much as you guys can.
Okay.
Teachers.
Who wants to start?
Do you want me to start? I will start.
I guess so. Yeah.
I am, my name's Stacy Vero, and I am a circuit rider and education manager with Preservation Connecticut. And I have been working in the field for about 20 to 25 years, and worked with Mary in the past. And that's your segue, Mary.
Okay. And I'm Mary Dunn, and I work for the State Historic Preservation Office, which is located in the Department of Economic and Community Development. My main jobs are grant administration and also liaison with local historic district commissions across the state and CLG coordinator. And Stacy was our National Register coordinator about 10 years ago, was it, Stacy?
That's a long time ago now.
Yeah. So yeah. Anyway.
We're lucky to still work together in this capacity. Which is very nice.
I like this better. All right. So tonight we are going to do our usual basic training. I know a lot of you are well versed in what I'm about to share, what Stacy and I are about to share. But we also are going to take the time to answer some specific questions you have and concerns that you're specifically working with. So this is just sort of a springboard for any conversation you want to have, but we'd like to just kind of frame it in the basics. So Stacy's going to manage the program, the thing, the PowerPoint. And
Can you all see it, by the way?
yeah.
Okay.
Great. Okay. So I guess we could get started. Okay. Oh, and thank you so much for accommodating this video, this remote training. I really appreciate your consideration.
Thank you for doing this for us. So
Oh, sure. Hope it's helpful and enjoyable. Okay. So you're probably all familiar with the general statutes that set up local historic districts, municipal enabling legislation that was enacted in the early 60s. And it was meant to help municipalities decide what was important to them architecturally and historically, and then put in place legislation to help protect your distinctive historic resources and architectural resources, and at the same time, promote the benefits, educate the public, and talk about the economic and cultural benefits of local preservation. Next slide, I guess. So as a commission, the statute does require certain parameters. You need to have 5 regular members and 3 alternates. And the alternates should really attend every meeting, whether they expect to be seated or not, just so that they can, just be familiar with the work of the commission and how it operates, and make sure they have, smooth institutional knowledge. And it's recommended in the statutes, or suggested in the statutes, that at least one person be a district resident. Some commissions, everybody's a district resident, but at least one is a good idea. Fairfield is a certified local government, and I'll chat about that just a little bit later on. But as a CLG, your commission is required to be staffed with members that have a demonstrated interest and support in historic preservation. Ideally, we like to see members with professional qualifications, which you do have, um, you know, at least 2, but barring that, everybody on the commission needs to, have a support preservation. As you'll find out later, you cannot be a CLG commission and not support preservation. It's counteractive to the relationship that you have with our office and with the National Park Service. You should stagger your expiring terms so that everybody doesn't go off at once and a whole brand new commission is put in place. And the officers that you need to have are chair, vice chair, and clerk. Next slide. Your primary responsibilities are to develop rules of procedure, which should follow your town meetings procedures, especially putting in place a conflict of interest statement, which can also just be your town's, whatever governs the boards and commissions of your town. There's an annual report that's due to me on your membership. So if you have new commissioners, I like to see resumes of the new commissioners, and also just reporting on your activities. I don't need copies of minutes or anything, but it's nice to see, how many COA applications did you get? How many were approved? How many were denied? Things like that. If there's any new legislation that was put in place, there's usually not, but, sometimes towns put in place incentives for historic preservation or, things like that. And then you should be adopting, this says regulations. I don't know any commissions that actually have regulations, but most commissions do have design review guidelines, so that the property owners in the district will know, how you operate, what they should expect during the COA process, and how you review work for issuing a certificate of appropriateness. Next, please. So as you know, your COA process is public. It's a public hearing, and you do need to notice them, no less than 5 or more than 15 days in advance. In order to vote on applications, you have to have a quorum present. You just need a simple majority of members. Applications are decided by majority vote, and you do need to take action within 65 days of filing. Not 65 days of the first meeting you have after an application comes in, but 65 days after that application is received by the town. And sometimes you can issue a COA with stipulations. We always use the same example, but if you approve a solar installation on a roof, once the lease is up or once the panels are no longer operative, you can ask that they be taken off so that they're not just these vestigial, things on the roof for the rest of the life of the property. Next slide, please. So I just got this question today from another town that was planning to establish a district. Your work and your ordinance is regulated and enforced by your town's zoning enforcement official. The building inspector might start off by, looking at work that's being done, or anybody that the town designates in the ordinance. But the point is the commission does not enforce your work. You do need to go through your zoning enforcement official. And so if somebody violates a COA or doesn't get a COA and does some work, you can take action in Superior Court, ultimately. And the court can act to restrain whatever violation is taking place, or, put an injunction on the work until it can be corrected or removed, or you all come to the table and decide what the best course of action is. Next slide. And those penalties can also carry monetary implications. The statute does allow for daily fines of $10 to $100 usually for infractions that are like the homeowner didn't know, the property owner didn't realize they were in a district, or they didn't realize they had to come to you for a COA. But once they find out and they're not correcting it, you can impose fines. If it's egregious, if they know they're in a district and they know either you denied a COA and they do the work anyway, you can impose fines of $100 to $250 a day. Next slide. So there are certain exemptions from your purview. Paint color is specifically stated in statute that it does not come under your purview. State properties don't comply with local ordinances. If it's truly ordinary maintenance and repair, no changes to design or materials, your property owner does not need a COA. If the building inspector cites a public safety violation and requires the property owner to correct it immediately, they don't have to come for a COA first. If someone got a permit right before a district was designated, they're grandfathered in, they don't have to get a COA. Nonprofit institutes of higher education are exempt. That was just something that Yale got in there at the last minute, I guess. I don't know, there's nothing, because most nonprofit institutes of higher education have beautiful historic buildings, but they're exempt from the COA process. And you don't really have any authority over blighted properties. You cannot compel a property owner to do something with their property, but you do have standing to work with the town to either create or strengthen a blight ordinance through your zoning. Next slide. Yeah, okay. Got it. Everything's on. Okay. So as you meet and review applications, there's just some tips that we like to give out. Make sure you have as much information as you need about the project, including, what materials are being used, what work is exactly being proposed. Especially if it's new construction, you want to see design drawings, elevations, information about materials, site review, things like that. And then, of course, come prepared, having read the application and any questions you have ready to go. If there's a conflict of interest, just recuse yourself before the item is even opened. So sometimes the chair can say, these are on the agenda. Does anybody anticipate a conflict of interest? And then so it's announced before the hearing starts, and then once that agenda item comes up, the commissioner will just recuse themselves. And that means no comments and just you're out of the process. When you're talking about work, use objective statements and data. Try not to let your personal feelings or opinions enter into your discussion or your decision making. Try to be a resource for the property owner, especially if they're coming to you and they feel that they need to, replace all their windows and you're like, no, that's not appropriate. We can't approve that. Try to help them find a resource for funding, find a resource for a skilled person that could actually restore the windows instead of, resorting to replacing the windows. Don't ask questions that are outside your purview. Generally, if you have a problem with the use of the property, that's outside your purview. So all you can do is review the changes to the exterior architectural features that are visible from a public way. So, don't say, I don't want a fat rendering plant in my neighborhood. If it's allowed, it's allowed. So all you get to do is review any work that's required. And then, acknowledge the public. It's a public hearing, and ask for comments as applicable. Next. So I mentioned design review guidelines, and we really recommend that you use the Secretary of the Interior standards as a basis. In fact, we just gave you a grant for guidelines, right? So yay. Okay, good. I'm looking forward to seeing those. They're objective, they're flexible, but they're not arbitrary. They've been around for a long time, and they provide a framework for all types of decision-making situations. And they include information on all types of materials, all types of buildings. It's a good place to start. Next slide. please. So what are the standards? You probably know this. I'm sure you do. Now the standards, of course, apply to the inside and the outside of buildings, but as you know, you only have purview over the outside. But the main highlights are that you want to retain as much historic and architectural character of a property as possible. And so if there's a feature that is deteriorated, you want to try to repair it if possible. If you can't repair it, and you need to replace it, you need to replace it in kind where possible. You especially want to be protective of workmanship that just is no longer readily available, like woodworking or plasterwork or, even stucco, just things that are, because once those features and workmanship are gone, you no longer have them as a guide point. So basically those are the standards that you would work with. Just try to repair rather than replace in kind, and definitely pay attention to unique examples of workmanship and materials. Next, I guess. So I mentioned earlier that Fairfield is a certified local government. And the CLG program was instituted in some amendments to the National Historic Preservation Act of 1966. They were instituted in the 80s. And it was a program developed to link federal, state, and local governments into this preservation partnership to help local governments protect, what was important to them. The first act of 66 kind of dealt with nationally significant resources. And then as time went on, the SHPOs were identifying state significance, and then the CLGs were put in place to help carry out local. But the CLGs are also in place to help carry out the national goals of historic preservation. So it's a very powerful preservation partnership. It should give historic preservation legitimacy in your local government. It's something that is requested from your chief elected official. So it's sort of a statement that the town really wants to consider its historic resources in its planning, in its preservation program, especially with planning. So it should really develop not just a partnership with our office and the National Park Service, but also with critical offices within your town, like planning and zoning and land use and economic development, things like that. And the HDC is the de facto Historic Preservation Commission for the CLG. And so, you're the group that I turn to, if I need information or advice, or if you need technical assistance or funding. So as the Preservation Commission, the HDC should really carry the torch for preservation, and really take this partnership seriously, if they can. Just take a water break, sorry. So there are about 54, there's a lot of CLGs in Connecticut, Fairfield being one, obviously. I forget, I have that information, but I'm not sure when you were actually established, but you've been around for a while. Next slide, I guess. And you do have certain responsibilities. At one point, your chief elected official signed a certification agreement along with our SHPO and the National Park Service to undertake certain responsibilities. Foremost being enforcing local legislation. That's your basically your Historic District Commission. Local preservation legislation. We talked a little bit about the makeup of your commission. So a CLG commission has to have an adequate and qualified historic preservation review commission, and that's you. Composed of all professionals or lay members that have a demonstrated interest and support in historic preservation. You need to maintain a system for the inventory and survey of your historic properties. That's your historic resources inventory, which you do have. I'm not sure how old yours is, but if you are looking to update that one, or
Yes.
Okay, good. Or explore a
We
new
were just
area.
talking about this, yeah.
Okay, good. We can offer a non-matching grant to hire a consultant to take care of that.
Yep.
Since we don't want to have an unfounded mandate. So, that's that. You do probably already know this, but you participate in the National Register program. The National Register program is a federal program that is administered by our office. And the certified local government has a say. If we get a nomination from a town that's a CLG, we do kick it back to the commission and the chief elected official, and we need concurrence from both of you, either or both, in order to move forward in the process. If for some reason one of you agrees that the resource meets the criteria for National Register listing, then we stop. We don't take action. We don't review it, and we do not forward it to the Park Service. So other things, we do expect you to participate in training, like, especially if you identify specific topics that you'd like to learn more about, definitely contact me and or Stacy, and so we can help you out with that. We do a review every 3 years. I've been doing desk audits a little bit because of COVID, but ideally I would come on site and just observe a meeting, or it's just basically an evaluation every 3 years. And then in addition to that annual report that I talked about earlier that every commission has to submit, there's also a report to the National Park Service, but I create that form and I send it to you for filling out. You don't have to worry about dealing directly with the National Park Service. So yeah, that's CLGs. And the benefits, as we just kind of mentioned, are tangible in that we do have a special pool of funding for you, non-matching grants of up to $20,000 for things like design review guidelines or public education materials or anything that has to do with historic preservation, education, or outreach. We did this year purchase memberships for our certified local governments in the National Alliance of Preservation Commissions, which I think is a really useful membership. And Rosina, I know I will email you about what's going on with your membership. I think they emailed it to a general Historic District Commission email inbox. So, and they do send things by email. So they just went to HDC.
Yes.
At Fairfield, Connecticut, or something like that.
Yes.
If that's not where you want it, I can have them send it directly to you, to your email. Just to make sure.
I'll look in the HGC one and see.
Okay, look there, and if you didn't get anything, let me know. And you can either through me or directly to the NAPC. You can send the email addresses of every commissioner that you have, your chief elected official, your zoning people. It's an organizational membership, which means that it's not just for one person. Everybody can take advantage. And you don't get a ton of emails, but the emails you do get are really good because they're usually for free webinars that address all kinds of not great, but issues that most commissioners are working with. So it's a great membership. This was the first year we did it, but we hope to do it on a yearly basis, obviously. I guess that's it. Okay. Keep. Okay, so I just said that the non-matching grant is called the Historic Preservation Enhancement Grant. It is the federal funding. Our office receives an appropriation from Congress every year, hopefully. And we give 10% of that out in grants to the CLGs. We're required to give at least 10%. We usually give more than that, but at least 10% of the total fund has to go to various grants.
Did we apply for that training?
I guess next slide. And then when the Community Investment Act was enacted like 20 years ago, it infused a lot of extra cash for historic preservation purposes and other purposes. And so we developed an additional funding source called the Supplemental CLG Grant. And that's just another little pot of money. It does require a match except for the surveys, but it's just an extra opportunity for CLGs to apply for funding. I guess that's it. Okay, so you did have some specific questions related to the work that you do. Unless you guys have other questions or want to, whatever, or we could just keep forging on.
Keep going unless anyone has any questions at the moment.
Just about the, do we want to apply for that grant for our training from the town? It's
We
only
could,
a couple-
I think
it's
that's
only
a
couple
larger,
thousand. It's only a couple $1,000.
I think first we should go and talk to everybody about the design guidelines and I don't think we can have multiple open grants. And if we want to do the historic resource inventory, I think
That's
we
better.
need to
That's really,
prioritize.
that's really important.
Okay.
But
You can-
actually, once you close out your design review guidelines, you can apply again for a federal grant.
Yes.
But you can simultaneously have a supplemental CLG grant. You could apply for one, and that's
Okay.
if it's for a survey, that's non-matching. So you could, but I understand that these grants do take administration, so you don't want to bite off more than you can chew. But that's available to you. So
Thank you.
so Stacy and I were talking about so with local historic districts, unlike the National Register and even the State Register now, there's no distinguishing between a contributing resource and a non-contributing resource. Everything within the boundaries of the local historic district is subject to the review of the Historic District Commission. Even a building that was built in 1999. The difference is just a few things. You don't want to create a false sense of historicity. So you don't really expect that 1999 building to look like, an 1899 building if it doesn't already. You basically, any work that's proposed by the property owner just needs, you almost treat it like it's like you would new construction. Look at the materials that are being proposed, look at the design, and just make sure that it is congruent with the rest of the district, or at least as congruent as it already is. Okay, so if someone lives in a house and they want to replace their roof and the roof has asphalt shingles, you cannot ask them to put slate on or wood shakes, even if that's what all the other houses add or have. So you're not reviewing it as it's an historic property, but it is in the district, and you want to make sure that it's not you want to make sure it's compatible with the rest of the district as much as you can. And Stacy, I thought you had something way more pithy to say about that. Did you have anything, or is that
Sorry, I've got to help her.
your buddy?
I think the idea is, you want to keep the review process consistent, no matter what you're looking at. So if it's, if you're reviewing a newer property, you want to treat that property owner with the same level of sort of process that you do your historic properties, but you want to be sure that whatever they're doing isn't going to massively alter the character. I gave this ridiculous example here for you to see, but this is new construction, but it's also, the existing construction can be altered in such a way that is really incongruent with the surrounding character. And just making sure that, again, as Mary said, you're not creating a fake Disney replica of something, but you're also being just consistent. So if you have a study report, which I don't think you do, that has really specific descriptions of the properties as they were listed in the study report, that's very helpful. And I think you have an older study report. So I think your design review guidelines as written, hopefully, talk about this a little bit, and maybe you can alter them to include a little bit of this language, but making sure that you keep these sort of subjective qualities of character and feeling intact, and that's difficult. But it's also, as the slide says here, that accumulation of changes and impacts on a district that have the detrimental effects over time. So just being aware of the cumulative impacts of changes, even to new buildings.
Yeah. Okay.
And as with everything, it always comes back to your general things, right? Setback, scale, massing, materials. Those are the things that we always tell you to look for, whether it's new construction or existing construction. Right, Mary? Anything else?
Exactly. Exactly. Okay. Okay, and we can talk about this more in Q&A if you want, but I guess we could go to the next slide for now, I suppose. Another big question that comes up with commissions is, how to deal with substitute materials, not deal with them, but how to address them. And we're not saying that substitute materials are always not the best selection, but there's just some questions that you should maybe ask before you decide. And the biggest is replacement even necessary? Again, I was talking to another town this morning, and they said, oh, this person wants to replace all their windows and the vinyl ones are cheaper than the wood ones. So how do we convince them? And I'm like, take replacement off the table. Is replacement even necessary? Because, and our last bullet says it's a whole different topic, windows, because we could do an entire workshop on those, and we'd be happy to do that. It's just that you just want to make sure that it's even necessary. I mean, somebody might come to you and want to take all their clapboard off because one piece is warped. Make sure that they're not taking drastic measures to begin with. Is whatever they're proposing reversible? If the original material is not around anymore, not available anymore, maybe you can consider a substitute. But that doesn't mean, I went to Home Depot and they don't have it. It means, really, really make sure that you cannot find that material. The big thing for us is proven long-term performance. So yes, ask for samples of the material so you can really look at it and see if it really is like slate or whatever. But even better, find out where this material has been used or installed on another building, how long it's been there, and see what it looks like. Most of our concern is we just don't know. Well, sometimes we do know what the short-term performance is, and very often it's not good. So that's a good reason to not accept something. But just because something looks good when you put it in the first day doesn't mean it's going to weather that well, and in some cases it will be disastrous. In some cases you'll have pitted, yellow, delaminated features, and you're just going to want to replace it again. So that's important to know that. And you want to make sure that the person doing the work knows how to properly install the material. And there is a difference. Stacy put this example in, a fence or a railing is different than a turn spindle porch balustrade, or the deck of a porch. You might allow a composite material because you can't see it, but you can see a fence, so you may not allow a vinyl fence or a composite material fence. So those are things to consider as well.
And we have done whole training sessions on substitute materials in the past. So there's a lot to consider here, and certainly we can discuss it further with you all if you have questions. And we have some examples on the next slide of resources, which we will also share with you via email. But the resources that we provided here are the ones that are pretty well known. The first one is the preservation brief from the National Park Service, and it has been updated, Mary and I learned, in 2023 to include a little bit more leniency when considering certain types of substitute materials. But really it's very similar to the basic parameters that Mary just outlined. You know, avoiding substitute materials at all costs, when there are other options available, when there are original options available, or original materials available. So we also uncovered, in doing a little bit of research, some documents from a trusted source, and Mary can explain this a little bit more, but a lot of very savvy companies are advertising, and they're sort of couching all of that as information for people. So you might be encountering some pretty sophisticated marketing for your constituents and for your applicants that they're being sort of led down the path on. So that's something to consider when you're reviewing applications. But we will include the links here. The Columbus Alternative Materials Report is one that I think, it's a little old now, but it has a study of local historic districts throughout the country, and it compares each type of substitute material and locations where they're used and the frequency with which they're approved by local historic district commissions. So that is a very useful resource. So we'll make sure that you have the links to all of these.
Great. Okay. I guess that's it on that. I guess. Yeah, Stacy said a lot of times, and I don't want to badmouth anybody, but manufacturers will appropriate our language and use it to try to convince people that their product is approved. And it could be a little startling. So just I don't know, just be aware that sometimes advertisements are couched as information briefs. So
Yeah, on the National Trust website.
Okay, you said it.
I didn't say the product, but I said where. So just be careful.
Yeah, we were a little startled to find what amounted to a huge paid advertisement for a product we would never approve in the National Trust newsletter, and that was, or website, which was
Really?
crazy. But that's all I'm going to say. Anyway,
Wow.
okay. I guess, is that it, Stacy? Is it time for? Is there? Oh yeah, somebody said they had a question about some legislation
The
that is.
proposed bill. Yeah.
Do you want to take this, Stacy, or do you want me to, or what do you want to do?
Well, if you all have questions, we can just sort of talk about it. I mean,
Yeah.
You let us know if you've already discussed it in your meeting or.
In our meeting, I basically said that we were gonna discuss it here because you are more versed than any of us, so.
Okay, sure. So we
Great.
can run through the parts that are most pertinent to you all. The first is that you would have to simulcast these meetings. So they have to be live broadcast on a website as they're taking place. So there's that. I don't know. A lot of the people that we work with, I mean, you seem to have a fairly sophisticated setup here, but a lot of people that we work with don't. And I think it's going to be a tremendous burden on a lot of municipalities to come up with that system and put it into place. And it would make more sense if all of the public hearings had to be held like that, but just to single out historic district commissions, it seems unfair.
Yeah.
Frankly.
Yeah. I was concerned about the capacity of some towns to be able to do this. And when we shared this, more than a few did come back and say, how are we? I know that during COVID, it was a requirement but it wasn't, this is a little bit more. This is like a live broadcast on an internet website. I don't know. It just seems a little bit more onerous than, what they might have had to do during COVID.
And again, just unfair if that isn't the same,
Right.
bar held to every other public meeting.
Yeah, exactly.
And then I think the one that, state-owned properties are already exempt. Municipally owned properties are exempt from obtaining or having to go through the process of obtaining a COA. There is a review period that seems like it's purely advisory. So any municipally owned buildings would not be subject to your typical review process. I find that problematic in my experience working with HTCs because municipalities are strapped typically for cash. They typically are choosing the lowest bidder, and in many cases, understandably, but the thing that keeps them from doing that is the HTC process. And I think that helps tremendously. And having that voice matter is a very big part and an important part of the process. So removing that could be, I think, very detrimental to a number of buildings.
Yeah,
across the state.
and especially if you're a certified local government, the municipality should not exempt itself from its own preservation program. That is I find that very problematic on my end. One thing about this, though, is that because they're naming municipalities, I guess that means that that there's no question now that currently they are subject to the COA process. Because once in a while, I will get a town attorney saying, we're not subject, but apparently you must be. Otherwise, they wouldn't have specified this in statute. So that's one good thing about this. We really would rather it not pass.
Yeah.
And then the second bullet is
the worst
really,
one.
yeah, the worst, for lack of a better word. Currently, the property owner, the appeal process is to go to Superior Court within 15 days of a COA denial. But this would provide for appeals to the Zoning Board of Appeals rather than Superior Court, which takes the objectivity out of it in my mind, or in my opinion. Also, the Zoning Board of Appeals is not a qualified commission. I don't know how they would be making their decisions. And you are a commission in your own right. I don't understand why another board or commission would have would trump your decision. You are in place under an ordinance. This is your charge. I don't see why any other town body has any business in your business. So that's not a good one. I don't know what you think, Stacy.
No, I think it's horrible. And because I think we come across a lot of situations working with historic district commissions across the state where, for instance, one recently, the Historic District Commission was hoping for a letter from us at Preservation Connecticut to help save a building, and the letter was presented to be read at the zoning meeting, and the zoning folks didn't even read it. So I think there are some times where there's this tension. I don't want to say all the time, certainly, and I hope that the relationship you have with your zoning folks and your planning folks is solid, but many times it's not, and many times the Historic District Commission is considered sort of a I don't know, throwaway type of commission, and they're treated as such, and that's been really difficult. So if you have to go before the Zoning Board of Appeals in a town and say it's a municipally backed project, that's even worse, right? So a development or something that was going to take down some historic buildings. We've come across that over and over again. And the HDC has standing now, it can bring it to Superior Court. It's just going to disappear. So that standing will disappear in many ways. And the Zoning Board of Appeals doesn't need to live broadcast their hearings necessarily. So not that we know.
Yeah.
So it's an unqualified board for this specific topic. And if you're a CLG, that's a whole other layer. So it's a disaster. And we've been getting a lot of people very concerned about it and reaching out to us. And, we've been doing the best we can and talking to whoever we can to see if we can change that.
Yeah.
But it reads very nicely. It reads as a positive thing. It reads as like it'll be great for everyone. But
yeah, I'm not sure where I have my suspicions as to actually a lot of towns, every town thinks it's coming from their town, which doesn't bode well for for relationships between the commissions and town managers or town bodies. But yeah. But I believe there's been a lot of vocal opposition to it across the state. And I hope that the legislators are understanding. Well, they won't understand the implications unless people point them out to, so it's good that there's been, conversation.
So what's the status?
There's still a little less than a month to go in this session, and it's still live as far as I know.
I tracked it this morning. It was voted out of committee and unanimously voted for. So when it was voted out of that, so I think it's being evaluated. I don't know who it goes to first. It's kind of hard to track the bill itself. We know that it's in a holding pattern right now, waiting to go before either the House or the Senate. I don't know which one.
Yeah. I think if you want the best information, maybe contact Connecticut Preservation Action or Preservation Connecticut. Stacy, does Jane, do you have, I'm just trying to think of, who would have.
We have a lobbyist. We have a lobbyist, and we have the vice chair of the appropriations committee on our board. But they have been trying to track this too. I think it's, we just talked about it this morning and we didn't have any updates. So I think we just have to wait until it gets placed sort of for vote. But I think as much opposition as, you can put forth if you're against it, it'd be really helpful to get it in as soon as possible, because as Mary said, it's May 1st it closes. I
think May 6th,
session.
But yeah,
May 6th. Okay.
Close enough.
So there's not a lot of time left, but anyone that you can round up to organize against it makes sense.
I'm sorry, what's going to happen?
I believe that's the end of the session, or at least the end of the voting.
Okay, thank you.
Okay.
Thank you. Let's see if we have any questions. Anyone from the public or from the commission?
We'll get a copy of this with the links.
Yes.
I'm just a member of the public. I'm not a member of the commission. But it looks to me like the appeal process renders the actions of this committee, this commission, legally meaningless. Because if someone's unhappy with the decision, they go to the zoning board of appeals. The zoning board of appeals does what we used to call elementary school a do-over. It just starts a complete do-over. What this commission decided has no meaning, no legal meaning at all. The zoning board of appeals starts afresh and hears it, and we just ignores what this commission did. Legally ignores it. I think that's the most powerful and detrimental part of this legislation, the perspective of this commission.
Basically, it neuters HTC.
Yeah. Yes.
Yeah.
It does. I mean, I'm not even sure what participation the commission would have in that ZBA hearing, so, which is, at least if it goes to Superior Court, all sides are heard and an impartial judge makes, a decision.
But also, in Superior Court, the standard of the burden is different in Superior Court. The burden in Superior Court is, was there any substantial evidence to support the commission's decision? In the ZBA, it's a complete do-over. It's a de novo review of the ZBA.
Right.
Yeah.
Yeah.
Yeah, it's a disaster as far as we're concerned,
It also eliminates the opportunity for case law. I mean, there's a huge body of case law related to preservation in Connecticut. And if things don't go to the courts, then how, not that there's precedent, but, it does provide learning and it's just a more objective and way of operating.
But the other thing that's frightening about it is I'd say most residents who buy homes, for the most part, want to do the right thing. What this really opens the door for someone who comes in, it's a developer who has a most absolute commercial perspective and probably isn't gonna live in the district.
Yeah.
Yes, I need to be careful what I say, but I would imagine that a developer, yes, they would simply just skip the commission, go to the zoning board of appeals, probably be upheld because it has the potential for political, for making decisions based on politics, not on, you know,
Yep.
the ordinance.
Any other questions?
Oh, just want those links.
Okay. Well, thank you very much for the presentation. This was very helpful. We look forward to receiving the links and we might reach out to you guys again for other training sessions. So,
Great, please do.
Yeah, I'd be interested in learning more about alternate materials
Okay.
because
Yeah, as Stacy said, we have a whole presentation.
we've been a staunch supporter of natural materials.
Good.
And and I think we pretty much maintain that very carefully. But, you know, we gotta listen to the world too. We can't be isolated island. So
No,
it would
absolutely.
be interesting to learn more.
And you want to
Um,
support your decisions with data and, and facts, not,
Right, exactly.
but it's a good opportunity for conversation, and for rethinking whether work even has to be done in the first place,
Yeah,
just
I agree.
want to make sure that, assumptions are questioned, before certain things are done. So,
Yeah, especially when they're irreversible.
exactly.
The more historic properties in Black Rock in their district was just approved for vinyl siding.
Mm.
So,
Really?
yeah,
A big one I know that comes before a lot of HTCs is Rhino Shield,
Yeah,
Mm.
which is awful.
And that
Yeah.
I would make sure people understand that constitutes a change of material. That's not
Yeah.
paint.
Yeah.
And so
Yeah.
they would have to come to you for
Yeah.
approval. That's not just ordinary paint job.
Yeah.
yeah, for sure.
Hmm.
So that would be interesting.
so we'll be in touch for
Yep.
For that.
other dates.
Thank you very much.
Great.
Thank you.
Great.
Thank you.
Very much.
Thank you.
Thank
Have a-
you.
Good
Have a-
luck.
Have a good evening. Thanks.
See you guys soon.
Is there a motion to adjourn?
I'll make a motion to adjourn.
And I'll second.
Oh.
Okay.
uh,
All in, this is separate. All in favor?
no problem, sorry.
Okay.